Hello. In this video, we're going to look at the question, what is administrative justice? If you're studying public law with us at Sussex, at undergraduate or master's level, you'll notice that we place administrative justice at the heart of what we teach in public law. But before we can see why we do this and why administrative justice matters to the study of public law, we need to get a clear picture of what do we mean by administrative justice. Not just a definition, but an understanding of the reason why we foreground it when we study public law. But just at the beginning of this video, in order to make sure we're all on the same page, let's follow Michael Adler, who we'll be talking about later, and think about administrative justice as one branch of the justice system, alongside civil justice and criminal justice. Looked at like that, administrative justice is the branch of the justice system that deals with decisions governments make in administering public policies that may impact the rights and duties of persons, of individuals and companies. Before we get down to discussing this in detail, I'd like to start with a distinction that the political philosopher John Rawls makes between a concept and a conception of justice. So, the way John Rawls uses these terms, the concept is the shared idea. You might think of what justice is. The conceptions of justice are the competing accounts of what justice requires. So we can think of a concept of administrative justice, a general idea that we can all agree on. But when it comes to particular conceptions, people disagree because they have different values and beliefs, and sometimes different interests. Those disagreements won't be solved simply by understanding each other better, although we can at least reach some understanding and respect for one another's views. So first I'm going to explain the concept of administrative justice, and then I'll show you a taxonomy of competing conceptions of administrative justice. And to talk about these competing conceptions, I'm going to use some research that I've done with my colleagues T.T. Arvind and Simon Halliday. One of the leading thinkers in the field of administrative justice, Michael Adler, defines administrative justice as the principles that can be used to evaluate the justice inherent in administrative decision-making. And Adler adds that this includes procedural justice, that is, how decisions are made, how people are treated, as well as substantive justice, which looks more at the outcomes, the benefits and the burdens placed on different people who are affected by a decision. So if you start with that definition, you'll notice a few things. Here's three things I hope you'll notice. Firstly, the concept of administrative justice is normative. It is about how administrators ought to decide matters, not just how they do decide them. Secondly, and expanding a bit, it involves external mechanisms, Adler adds, like courts, auditors and tribunals, as well as internal mechanisms, like when agencies reflect on and improve their own processes, or institute internal complaints processes or reconsider a decision. And third, administrative justice is about more than mere legality. A decision may be lawful, but still administratively unjust. And we sometimes use the term maladministration to capture these legal but unjust decisions of public bodies. And finally, we should note that administrators as a category today doesn't just mean civil servants, if it ever did. It includes all manner of decision makers, including private companies delivering public services under contract, say a firm doing disability benefit assessments on behalf of the Department of Work and Pensions. So let me give you a real concrete example. one that I know in my experience as a councillor for Seaford Town Council. A district council might grant planning permission for the town football club to use floodlights. The town council then, as landowner, then has to decide whether the floodlights may in fact be used on their land. Now, a decision to grant this permission helps the football club and its fans, but it may harm local residents through light pollution or extra noise late at night, or it may encourage antisocial behaviour that sometimes accompanies football matches. So, a decision to allow the use of floodlights, is this the right decision? People will legitimately, rightly disagree. But was it fair? That depends on your conception of administrative justice. Maybe you care that all sides were heard or that the town council was impartial, in the sense that no one who had an interest in the decision, by being a player, for example, was involved in deciding the matter. And if those criteria were satisfied, you may say, I don't like the outcome, but the process of reaching it was a fair one. But here's a point that even lawyers sometimes struggle to grasp. Administrative justice is about more than fair processes. In the example I've just given, a decision to allow floodlights confers a benefit on the football club and its fans, and it imposes a burden on local householders. Is that a reasonable burden? Does it ignore particular interests? Does it ignore certain aspects of the law and the protection that the law gives to some interests over others? For example, Article 8 of the European Convention on Human Rights gives rights to individuals to a respect for their private and family life. Maybe the council failed to give due weight to the private and family life of householders, and maybe this resulted in an undue burden on the householders to the benefit of the football club. So these kind of substantive issues also arise in relation to administrative justice. This is just one fairly low-key example. But this kind of decision is the sort that governments at different levels make every day, by processes that you might think are fair or unfair, or which you might think are substantively unfair by unduly benefiting one party and conferring an undue benefit on another. Think about every time a benefit claim is refused, or NHS treatment denied or approved, or an asylum seeker granted asylum or deported, a business license granted or refused, a home bought compulsorily or ordered to be demolished because it's unsafe. So there are tens of thousands of such decisions made every day in all levels of government. Most of them, we might hope at least, are made fairly, both procedurally and substantively. But mistakes happen, and sometimes the mistakes are huge. Like the Windrush scandal, where long-settled residents with the right to remain in Britain indefinitely were wrongly deported en masse, and when the mistakes were discovered, compensation was slow to be given and unevenly applied. And even when the law is applied correctly, justice must also be seen to be done. As Lord Hewart once said, it is of fundamental importance not only that justice is done, but that it is manifestly and undoubtedly seen to be done. That's why administrative justice focuses on both the outcomes and fairness of the process and the transparency in which decisions are made. This brings me to another important point. Administrative justice is not just about the big cases. Approaching the study of public law through the lens of administrative justice focuses our attention on the everyday encounters between private persons and public administration. This includes citizens and non-citizens, for example, people making an asylum claim. It includes individuals, of course, but it also includes companies, commercial entities like a small firm applying for a business license or a government grant. And these decisions are often mundane. They're rarely headline news, but they can transform lives. Contrast this with the constitutional showdowns like the Miller cases about Brexit or prorogation. Whatever their constitutional importance, Gina Miller was not a victim of administrative injustice in the way that many of the Windrush generation were. And remember, most administrative decisions never reach court. Judicial review, the legal procedure by which the courts check the decisions of public bodies, is really important, but it is only really a small part of an overall landscape of administrative justice. Other forms of redress, ombudsmen, monitoring officers, auditors, tribunals, appeal panels, mandatory reconsideration, complaints, are often cheaper, quicker, and more effective. Imagine if I, as a councillor, failed to declare a conflict of interest. In the floodlight example, if I was a player or my sons were in the junior team and I failed to declare this, you might sue in a court, make an application for judicial review on the ground that the decision was biased. But this would be expensive and slow. More realistically, you'd complain to the monitoring officer or object to the annual audit of the local authority. A body could order a rerun of the decision or issue a public rebuke. That might be the proportionate just outcome of what in this case might be a pretty minor infraction of the principles of administrative justice. So administrative justice is not just about legality, and it's not just about the courts. It's about the full range of mechanisms that are in place to secure justice in administration. So far, we've looked at the concept of administrative justice, and we've said that this is about fairness in process and outcome, and that decisions of administrative bodies are checked both by courts and by other institutions external to the decision-making body as well as internal to it. Now let's turn to conceptions of different ways of imagining what administrative justice requires. Here's where my work with T.T. Arvind and Simon Halliday comes in. We use Mary Douglas's grid group cultural theory to classify thought styles of administrative justice. In other words, to come up with a taxonomy of different ways of answering the question, what does administrative justice require? And so I must take a minute to explain Mary Douglas's grid group cultural theory, which classifies cultures as differing along two different axes. One is grid, the degree of regulation, how much rules and norms structure behaviour. At one end, decisions are conditioned by institutions, rules, differences of status, and so on. At the other end, we have the idea that principles directly regulate outcomes. And then the other dimension is group, which refers to the degree of integration. How much do people see themselves as bound into a collective as versus individual free agents? And if you put these two distinctions together, you get four cultural types or thought styles. Individualism, low grid, low group. Egalitarianism, low grid, high grid. Hierarchy, which is high grid and high group. And fatalism, or the isolated position, which is high grid and low group. And so with Arvind and Halliday, I've done some work that applies these classifications to the discussion of administrative justice conceptions. In the diagram that's now on screen, we can look to the bottom left quadrant, the low-grade, low-group individualist quadrant. Here, justice is about responsiveness to individuals in a competitive, conflictual world. Administrative justice is about navigating conflicting, discordant interests by references to core principles and fundamental values. Market and consumer sovereignty models of administrative justice fit here. Justice is done when administrators respond to user preferences or when consumer choice disciplines the provision of public services. At the opposite, top right quadrant, we could see that justice in administration is about impartial rule following in a tightly regulated, tightly integrated community. Bureaucratic rationality is one form. Apply the rules fairly and consistently, but professional treatment is another. Doctors, social workers, or experts applying specialized knowledge to meet needs are all examples of top right decision making and administrative justice. What these models have in common is that they uphold common interests by using approved rules, frameworks, and processes. Turning now to what Mary Douglas calls the negative diagonal, we can look at the top left quadrant of high-grade, low-group administrative justice. Douglas would call this the fatalist or isolate perspective. And the words conjure a much bleaker vision. Here, justice is rule-bound, but without the shared sense of community that we see in hierarchism. Sometimes, under conditions of austerity, though, this is the only honest way forward. Admitting that resources fall short and that it is going to be impossible to meet all legitimate claims for public services. Lotteries for oversubscribed school places or for small research grants like the British Academy Leverhulme Small Grant Scheme for scholars are examples. Outcomes are arbitrary, but they are at least transparent and free from hidden bias. Not everyone, the assumption goes, can get the benefit, so the conflicting interests of applicants are resolved using approved rules, frameworks, and processes, wherever they may lead in terms of outcomes. And finally, at the bottom right, egalitarian or enclavist quadrant, justice in administration means first and foremost participation and consensus. The focus in this quadrant, in this thought style, is on including all affected voices, deliberating openly and trying to reach a shared consensus. This is a radical transformative vision, aiming not just at fair decisions, but at a fairer society that involves manifesting and upholding common concordant interests by using core principles and fundamental values openly expressed. And I would say that there's a lot you can do with this framework in terms of critiquing particular administrative redress schemes for neglecting a perspective or perhaps overdosing on another to the exclusion of others, or understanding where particular critiques or scholars are coming from. But for now, I want to leave that aside and just reflect a bit on what this all teaches us about what is administrative justice. So what have we learned? Firstly, that administrative justice is about more than courts and legality. It's about the fairness of decision processes and outcomes in the everyday encounters between private people and public administration. And Adler gives us the concept of administrative justice and indeed several of the models that are apparent in public administration or models that he has clarified. I wanted to go further and suggest that the framework adapted from Mary Douglas by T.T. Arvind and Simon Halliday and myself helps us in mapping competing conceptions of administrative justice, putting them in their place, understanding how they stand in relation to others. And those conceptions matter because they explain why debates about reform are so difficult. People are often working with different visions, not of what administrative justice is, but of what just administration requires. So when we ask, what is administrative justice? The best answer, I think, is that it is both an idea and a contest. It's an idea because it names the principles by which we can judge administration. But it's also a contest because different people and institutions hold competing views of what these principles demand. And as you develop along your process of becoming public lawyers, you will be, one way or another, participants in that contest. Because the task of public lawyers is to navigate the contest with clarity, with care, and with an eye on the lived reality of those affected.